This is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the Harlan Institute ConSource Virtual Supreme Court competition. This year we are mooting the case of Espinoza versus Montana Department of Revenue. We are now moving on to the Elite Eight. Our top 8 teams have advanced to the next round, and we are thrilled to have 2 teams with us today. From Greenwich High School in Connecticut, we have Dylan Minnie and Dylan Maloney. They're representing the Petitioners. And from Judge Barefoot Sanders High School in Texas, we have Brooke Sanchez and Avery Rose, and they're representing the Respondents. Petitioners may begin whenever you're ready.
Good afternoon, Your Honor, and may it please the Court that I, Dylan Maloney, and my co-counsel, Dylan Minnie, represent the Petitioners, Kendra Espinoza, Jerry Ellen Anderson, and Jamie Schaefer in today's case of Espinoza v. Montana Department of Revenue. This case concerns the tax credit for Qualified Education Contributions Act, which in return for a tax credit of up to $150, an individual can make a private donation to scholarship organizations. One such program, Big Sky Scholarships, planned to allocate scholarships to religious and non-religious schools alike. However, in order to comply with Montana Constitutional Amendment Article 10, Section 6, the Montana Department of Revenue added Rule 1, which bans scholarships from going to religious institutions. This case asks whether said program is constitutional. It is not, and because justification comes from Montana's Blaine Amendment, we ask the Court to protect in judicial activism by ruling that the Blaine Amendment is unconstitutional as well.
Montana Supreme Court ruled with the respondent that the program was unconstitutional because it discriminated against those who wish to freely exercise their religion at their school of their choice, essentially saying that since Rule 1 is discriminatory, the whole program is thus discriminatory and must be shut down. But if Rule 1 is discriminatory and it stems directly from Montana's Blaine Amendment, then the Blaine Amendment itself is unconstitutional. We must... Go ahead.
The program is not a violation of the Supreme Power, which is the Establishment Clause, because aid is going to the individual's opportunity to learn and not benefit the religious institution. This would follow Cochran v. Louisiana's child benefit theory. As a result, the Court has continued to follow programs that do not directly support religion, as in Augustini v. Felton, which a New York program under which public school teachers were sent into parochial schools, and it decided that this did not provide parochial schools with any incentive, financial or other, to establish religion in order to attract public school teachers. Likewise, in Mueller v. Allen...
Counselor, if I could just interrupt you for a minute. What exactly is your basis for standing in this case?
Are you referring to Espinoza's standing?
Yeah, what is your Espinoza, your clients? What is her basis for standing?
Her basis is that the injury that she is facing is from having her financial benefit being declined, and this is clearly something that is a problem, because if you look at the case of Rosenberger v. University of Virginia, it decided that, denying the same funds given to secular paper, it imposed a financial burden on his speech and amounted to viewpoint discrimination.
Okay, so I get Rosenberger, but in that case, you actually had students who were paying a fee. Is Miss Espinoza a person who gave money to the scholarship? Is she suing as someone who gave money to the Great Sky program?
No,
it's someone who benefits from...
Well, no, I know, but for Miss Minnie, so she didn't contribute money. Is Miss Espinoza representing one of the schools that was denied funding?
No, she's representing her and her child's free exercise.
No, I get that, but is there any guarantee that she would actually even gotten this scholarship?
Well, Your Honor, she'd actually been, her children had been going to Stillwater Christian School and been receiving scholarships for their entire...
No, I get that, but what if no one had given money to the Stillwater Academy? She would get nothing.
Yes, that's true, but that's the same unfortunate outcome that comes when shutting down the whole program.
That's also something that should be between the citizens and the citizen rule, rather than something that should be controlled by the government, as Madison stated in his memorial and
No,
memorials.
I get all that, but I'm still not sure. Usually, when you have a establishment clause case or free exercise case, you have a taxpayer, right? Or you have a school. You don't usually have a student who wants to go to a school. In other words, why is this a concrete injury that this court should resolve?
Because the student does attend the school.
But she doesn't. But she can attend it anyway. Why does she have an entitlement to the scholarship?
Your Honor, she's being denied the scholarship when it did exist for her religious belief.
All right. So let me just Mr. Maloney, let me just pick up on your question, right? When you said when the scholarship did exist, it doesn't exist anymore. I think we can agree on that, right? It's gone.
Yeah.
So then what's her injury? If everyone in Montana is being denied this benefit, how is she being singled out at this point?
Because the benefit was something that should not be interfered with as the government. She is a recipient of this benefit, as we have.
What was? You said it correctly. She was. She's no longer eligible because the scholarship is gone. What is the ongoing injury? What is the ongoing reason why this court's resolve it? What's there for this court to resolve? The program is dead. Right? Why are we even here?
Your Honor, it's a right to education that's being deprived.
She can go to school. No one in the state's getting this money, though. There's no one getting this money. What is her injury? What injury can she claim at this point? She may have had an injury earlier in the case, but she hasn't done now. There's no scholarship program left.
Well, as we have stated, we are continuing to declare that the entire Blaine Amendment within itself is unconstitutional. So while we can look at this, as we said, at a judicial activism point of view, rather than simply attempting to rejuvenate this specific program, we want to prevent things like this from happening in the future. We want to examine the Blaine Amendment and its intents and its application.
Miss Minnie, so you think the Blaine Amendment is unconstitutional on its face or as applied in this case?
As applied in this case.
So,
and it could be applied very similarly in other cases due to the Montana Supreme Court.
Do you think there are any circumstances in which the Blaine Amendment is valid in any circumstance?
Your Honor, let me speak for my co-counsel here that the Blaine Amendment is unconstitutional on its face because this application is one of the core examples of how this could work. A similar example, in Virginia, in Rosenberger, they had a very strong Blaine Amendment, similar to the one in Montana, and that was ruled unconstitutional. And these...
which case are you citing there?
Rosenberger v. Virginia.
But that was not that did not involve a Blaine Amendment, that case.
It did because there was a Blaine Amendment in that state.
No, I know the state has one, but that wasn't part of the case. That's not why the school denied the funding. I don't think that's right. Let me move on to a different point. So I'll take your position that the Blaine Amendment's unconstitutional in its face. We'll just assume that's your position. What's the strongest case in your favor to show that the Blaine Amendment's unconstitutional? What's your strongest case?
The strongest case to show that the Blaine Amendment is unconstitutional, Your Honor, is one like Church of Lukuma v. Babalu I, the city of Hialeah, because it depicts how the Blaine Amendment was written in a discriminatory manner, coming from the late 1800s and anti-Catholic sentiment. And
I get all that, but what year was the current Montana Constitution ratified?
1972, Your Honor, and that was the comeback of the amendment, I'll say, because it was originally introduced then, and then it came back then in 1972 because at the time there were a lot of anti-Catholic riots. And
do you think is there any evidence in the record to show that Montana's Constitution from 1972 was motivated by anti-Catholic bigotry?
Yes, Your Honor. Oftentimes opponents of the Blaine Amendment in this specific instance call it the badge of bigotry. My apologies. And this was because at the time there were many anti-Catholic riots. So even
in the 1970s, there were Catholic riots?
Yes, there were, Your Honor.
Okay. All right. So let's just. I'm sorry. Go ahead, Counselor. I mean to interrupt.
So even people who were Christians and supported religion thought that by adding a Blaine Amendment, they could appease the other side. People who didn't want.
Okay. Well, yeah, Ms. Minnie, you may go ahead.
Additionally, with the idea of the Blaine Amendment being unconstitutional, and you talked about a specific case. I think we can apply this to the ruling in Rosenberger because of the way that they announced the ruling was that they were denying him the same funds given to a secular purpose. That is exactly the primary intent of the Blaine Amendment, is to deny the same funds because it is a non-secular.
Okay, well, counsel. Well, let me ask this question a minute. Let's assume that there was not bigotry, right? I think you said there was, but I think your friends on the other side said there's not bigotry involved. If we put aside the Lukumi issue, what's your next best case for arguing, that the Blaine Amendment's unconstitutional on its face?
Well, I would point to Trinity Lutheran v. Comer for that.
Okay, so let's talk about Trinity Lutheran for a minute, right? Trinity Lutheran was decided in 2017, right? It's a fairly recent case. If we remove Trinity Lutheran, does your argument become different? In other words, what's the argument without Trinity Lutheran, without Lukumi? Because those are all recent cases. What's your argument there? If we get rid of, because it's a recent case. I mean, these amendments have been around for decades, and Trinity Lutheran was only 3 years ago.
Well, I think it can be important to look at some of the primary sources of some of our founding fathers, some of our important figures. Many of them have stated that religion is something between God and man and should not be something that the government is interfering on. They should interfere on the free exercise of religion. The Establishment Clause, Jefferson was stating that the Establishment Clause would tend to restore the man to all of his natural rights. While the Establishment Clause, as being used in many cases today, is actually stripping Christians and other religions of their natural rights, and it's inhibiting their natural rights.
But counsel, when we're talking about Trinity Lutheran, that case about playgrounds and tire scraps and public safety. Here the money's being spent on religious instruction, right? Isn't there a huge difference between Trinity Lutheran and the facts in this case?
Your Honor, the ability for the kids to play is a generally available public benefit, just as education should be a generally available public benefit. Zelman v. Simmons Harris found that the program, which provided a wide spectrum of individuals with vouchers, was constitutional because there was a financial need and residents in a particular school district. So there is Trinity Lutheran, playground or education, they're both necessary for children. Education even more so.
Well, counsel, let's talk a little bit more about Trinity Lutheran though, right? Is this scholarship is the Blaine Amendment actually discriminating on the basis of religious status, or is it something more?
Well, the actual wording of the Blaine Amendment talks about how no public funds should be going towards any religiously affiliated causes, and using that wording, you could thus outrule Trinity Lutheran v. Comer. You could outrule all these Supreme Court cases that we have already determined to be constitutional because there is a religious affiliation. The amendment is so broad in its intent. You could rule out tax rebutes for charitable donations towards churches.
Counselor, is there any way to rule in your favor without declaring the state constitution, Article 10, Section 6 unconstitutional? In other words, can we rule for you, Mr. Maloney, without killing the Montana Constitution? Is it possible?
Technically speaking, Your Honor, yes, it is possible. The Montana State Supreme Court did that by killing the program on its face. But that is not the best option. We're asking the court to renew that program and kill the amendment.
So it's your position that we need to kill the Montana Constitution. Ms. Minnie?
I'm sorry. I think my co-counsel may have misunderstood your question, but he still made a great point. We can look at the child benefit theory to not necessarily, if you did not want to say that the Blaine Amendment was unconstitutional and you want to remain it as constitutional, we could look at the child benefit theory, where we look at this child who is attempting through a private scholarship program to achieve an education that they feel is best fit for them, and then by inhibiting their choice of which school to attend through a private scholarship program, you're inhibiting their free exercise. This is a free exercise case, and it's important to note that is the child benefit theory. The child is the primary beneficiary of this situation, and that is how we would approach it if not to call the Blaine Amendment unconstitutional.
Okay, you have about a minute left, Counsel. You may proceed.
Sorry, I'm having a little technical difficulty. To conclude, Montana's Supreme Court failed to protect their citizens' free exercise through the unconstitutional Blaine Amendment. The students involved in the scholarship program are simply attempting to fulfill the education most suited for them. Whether that be at a secular or non-secular school, should not be interfered with by Montana's state government as an obstruction of their right to free exercise. In memorial and remonstrance against religious assessments, Madison called those who obstruct free exercise tyrants and would be appalled at their attempt to interfere in one's religious freedom.
Your Honor, the last thing to remember is that the primary beneficiary of this program is the children. It's not the religious schools. This has been shown through Mueller v. Allen, Board of Education v. Allen. So we need to do what the children need. Here, let the children learn.
Okay, won't somebody please think of the children? All right, right on time. It's a Simpsons joke, which is probably from before you were all born. All right, respondents, you have 15 minutes. Avery and Brooke, begin whenever you're ready.
May it please the court. My name is Avery Rose.
Oh, Brooke, I think you're still on mute.
And my name is Brooke Sanchez.
Very good.
And together, we represent the respondent in today's case. Now, the petitioner has already addressed the facts of the case. If you have any questions, feel free to ask us, and we will address them as best as we can. For now, we will begin our arguments, for which we have 3.
Now, diving into our first argument, it's that the Montana Supreme Court did not discriminate when ordering the termination of the Big Sky Scholarship Program. Now, under Trinity Lutheran law, discrimination is created when an entity is forced to choose between maintaining its religious status and receiving a government benefit. So now, while Trinity sees a state-run organization deny religious schools government aid, today's case sees the entire program abolished, removing religious and non-religious students from accessing the Big Sky Scholarship funds. The petitioners were not forced to choose between their status as Christians and receiving a reduction to their tuition fees, because the Montana Supreme Court eliminated the entire choice for all families, regardless of whether the money was intended to go to secular or sectarian schools.
In contrast to Rosenberger, as our opponents brought up, in which a religious organization was denied the ability to print a newsletter, and Whitmire versus Vincent, where university policies were discriminatory because they applied restrictions only to religious organizations. Today's case sees religious and non-religious organizations treated in the exact same way. Now, during the argument, the petitioner mentioned that there is, that ultimately there is no discrimination when all parties are viewed equally in the eyes of the law and denied the exact same aid.
And that continues to our second argument, is that Article 10, Section 6 of the Montana Constitution, it's not unconstitutional under the Free Exercise Clause of the First Amendment. Now, the state of Montana has simply chosen to create a constitutional provision, and it respects the U.S. Constitution while protecting its own compelling state interests. Now, Article 10, Section 6 of the Montana Constitution prohibits the state from giving direct or indirect aid to any religious institution.
All right, Counselor, let me just interrupt you. So, I think my friends on the other side said Trinity Lutheran is their best case about why the Montana Constitution is unconstitutional. How do you deal with Trinity Lutheran, and what's your response to that, Counselor?
Well, Your Honor, in Trinity Lutheran, it is very distinct from our case, seeing as though the state aid that is given to the school is not for a secular purpose, for a sectarian purpose, is a secular purpose. The tire straps are not going to advance or promote religion in any way. The court ruled that it was more for the well-being and the safety of the...
I mean, Counselor, let me just read a sentence from Trinity Lutheran, right? The court... Hold on, let me just find the sentence I'm looking for. That's what I want to say. Okay. The court says, Trinity Lutheran is put to the choice between being a church and receiving a government benefit, right? It's discrimination on the basis of religious status. Isn't that precisely what's happening here? If this was a private military academy, they could have gotten the money. But because of the Blaine Amendment, they're not getting the money. Isn't that precisely the problem?
Well, Your Honor, in Trinity, the issue was that if you give it to one, you must give it to all. And that was if the program wished to continue. And in our case, Montana has decided to not discriminate and they decided to end the entire program on its face, seeing as though it would go against Montana's constitution.
I get that, Counsel. I get that. I'm with you. But maybe the answer then is Montana law is wrong, right? Maybe the answer is that the Montana Constitution violates Trinity Lutheran. How do you respond to that?
Well, Your Honor, the United States Constitution, the First Amendment, basically establishes a wall. As Thomas Jefferson mentions in his letter to the Danbury Baptist, in fact.
No, I love all this stuff. Jefferson Danbury Baptist is great stuff, but let's talk about Trinity Lutheran. It says you can't discriminate on the basis of religious status. That's the word they use, status.
Yes.
Help me with the word status. That's what I need help with.
Well, Your Honor, we're not discriminating based on the status of the petitioners in this. We're not discriminating against specifically religious people. In fact, the aid is being denied to all.
Well, it is now because the Blaine Amendment, right? We keep circling back to that point, but maybe the Blaine Amendment's wrong. Maybe you couldn't deny it. Maybe the free exercise clause prohibits you from doing that, right? How are you not discriminating on a religious status? That's a $1 million question for your side.
We're not discriminating against religious status because the fact of the matter is that the petitioners had no right to this or to this Big Sky program being created in the first place. Upon its inception, as you mentioned, it goes against the no clause, the no aid clause of Article 10, Section 6. And having said that, because of cases such as Zellman versus Simmons-Harris, in which...
Well, Counselor, let me try this a different way. Maybe a question for Ms. Sanchez. What was Justice Gorsuch's concurrence in Trinity Lutheran about? What did Justice Gorsuch sort of fork off the majority on?
I'm sorry, you cut out for a minute. Could you repeat the question?
What was Justice Gorsuch's concurrence in Trinity Lutheran? What did he sort of break off and talk about?
Well, in Trinity Lutheran, he broke off the fact that the state aid given to the school was not going to be advancing any religion, and that is he didn't want to discriminate against any religious institution. And if you go back towards the Blaine Amendment is more of a anti-Catholic.
Let me try this a different way. What was footnote 3 in Trinity Lutheran? What was footnote 3 about for the majority? Do you know about footnote 3?
No.
Okay. Ms. Rose?
Your Honor, footnote 3 was talking, if I do recall, footnote 3 was talking about specifically how the aid cannot be, it's basically saying that if you give religious aid, if you give aid to one, you must give aid to all, because it's for a generally non-religious purpose.
Yeah, not exactly, but I appreciate the. Let me just I'll bring you up because maybe I can ask a follow-up question, right? Footnote 3 drew this distinction between religious status and religious use. That is, in Trinity Lutheran, they were denied funding because it was a church, and that was their status. But the scraps weren't being used for religious purposes; they're being used for a playground. In this case, it's not merely the fact that it's a house of worship paying the money; it's that the money is being used for religious instruction. So, are you trying to draw a distinction between religious status and religious use? Is that maybe one way you can distinguish these cases?
Yes, Your Honor, we are. In fact, because this case is not a matter of denying folks who have a religious, who hold religious views. In fact, the standing the standing in Trinity Lutheran relies with the church who is being denied money and who's being, denied aid. In this case, rather than it being the church whose status is religious, it's going towards the religious views of a Christian.
Good. Yeah. So, Counsel, let me ask a follow-up question. It's for either of you. Is there any religious school that doesn't advance religion? I mean, are you ever actually going to find a school that identifies as religious but has zero religious instruction? Is that even possible?
Well, Your Honor, because we are not certain how much religious activity is going on throughout the schools, it is important that Montana respects and does not entangle in religion. Because we don't know how much religious activity is going on, Montana has decided to cut the program so that we are just...
Yeah, I get that. I get that. You worry about Lemon and the entanglement prong of Lemon. But let me ask a follow-up if I can. 37 states have Blaine amendments. That means I guess 23 don't, if my math is right. Those states are able to have voucher programs, like in Zellman, the case you mentioned, for math and science and history, right? Why can't Montana do the same? Right? In other words, if we kill their Blaine amendment, they can do the same thing that Ohio did in Zellman versus Simmons-Harris. Why can't we just kill their Blaine amendment and make them like the other states?
Well, to address that, in Zellman versus Simmons-Harris, the Supreme Court finds that it is possible, it is permitted to hand this money over. And even then, in Zellman, there were extreme circumstances. The Cleveland School District was one of the worst in the entire country. They were going through unimaginable issues in their education. Now, rather than having that same situation, in this case, it is permitted under Zellman to hand that money, but it is not required to do so. And as we see in Article 10, Section 6, this money cannot be handed over to religious institutions because there's a specific provision within their
right, and maybe that provision itself violates the free exercise clause. Let me ask you. Let me try maybe move in another direction. The issue here is that the Montana Supreme Court decided to level down, that they basically killed the program for everyone, right? Maybe the correct remedy then is to just say everyone gets it, and you don't have to have this no aid provision, right? Or let me ask that question differently. I asked that one poorly. Is it possible for us to rule in your favor without declaring the Montana Constitution unconstitutional? That is, can we rule for Montana here and leave your Constitution intact? Is it possible?
Yes,
No.
Your Honor. Yes, Your Honor.
That was okay. Well, maybe you can both go.
Your Honor, the Montana Constitution is very well constitutional, and specifically Article 10, Section 6, which does not allow us to give indirect or direct aid to religious institutions, seeing as back in Locke v. Davie, the Washington Constitution had a similar no-aid clause, and the court ruled that did in fact not violate anybody's free exercise, and that is similar to the Montana's no-aid clause.
Okay. You may proceed, Counselor.
Moving into our third argument.
Mr. Rose, you may proceed. Thank you. Yeah.
Our third argument is that petitioners want to reinstate the Big Sky program, which would force Montana to fund religious schools. The petitioners have blindly assumed that they have any constitutional right to the Big Sky program. From its inception, the program which the Montana legislature initiated had no value under the Montana Constitution, which is constitutional under the U.S. Constitution, according to Locke v. Davie.
Well, what about Church of the Lukumi? Your friends on the other side suggest that there might be some sort of animus or history of anti-religious bigotry, even in the 1970s, they say, right? How does your Montana Constitution survive Church of the Lukumi?
Well, Your Honor, in Lukumi, they were more worried about avoiding crime, and the crime of using these animals for their religious practices, and Montana does not criminalize religious activity. And in Lukumi, it says that the state cannot outlaw any religious practice.
But is Lukumi limited to criminal cases? Is that your position?
Well, it's limited that it's not trying to target religious people. It's trying to target the crime that is going on.
Well, what about a more recent case, Masterpiece Cake Shop, right? Are you familiar with that case?
No, sir.
Okay, you can proceed, Counselor. And you have about a minute and a half left.
The Montana Constitution, James Madison said in his letter, The Memorial and Remonstrance Against Religious Assessments, a just government instituted to secure and perpetuate needs them not. Such a government will be best supported by protecting every citizen in the enjoyment of his religion with the same equal hand which protects his person and his property, by neither invading the equal rights of any sect nor suffering any sect to invade those of another. The Montana Supreme Court cannot be required to validate the Big Sky program in agreement with James Madison, because it would force Montana to discriminate against religious schools. It would force Montana to provide aid to religious schools, and that would then cause the state to invade the rights of religion to the people.
And now, in summary, this case does not meet the standards of discrimination set forth in the rulings. The Montana Supreme Court constructively formulated the ruling of disbanding the Big Sky program, citing that it violated Article 10, Section 6 of the Montana Constitution. The petitioners argue to say that this provision violated their First Amendment rights. This, however, does not violate the free exercise clause in the United States Constitution, because the Montana Supreme Court decided to dissolve the Big Sky program in its entirety, rather than strictly discriminating against religious schools and the students wishing to attend the school.
Okay, and you have 5 seconds left, so we'll call it.
With that, we pray that this honorable court affirm the lower court's decision and find in favor of Montana in the case of Espinoza versus the Montana Department of Revenue.
Okay, perfect, excellent. Thank you so much. All right, thank you from the respondents. We now have a rebuttal, 5 minutes from petitioners. You can begin whenever you are ready.
While the program was shut down and it did offer the opportunity for students to attend religious and non-religious schools, the program essentially was being forced to choose between having religion and receiving funds from the government. The program, because it was donating towards students who would then choose to attend a religious school, was thus forced to choose an atheist approach by only giving students who want to attend a non-religiously affiliated school the opportunity to do so. Sorry, Donnie.
Yes, the program also made the choice of banning religion entirely, but this is directly targeted at Christianity. In the town that Espinoza lives in, there are, I believe, there are 5 schools and 5 private schools, and all of them are Christian.
What exactly was motivated by the anti-Christian bias here? Just be precise.
Well, on the decision, essentially the way that the petitioners interpret it, they'd rather cut off.
What's it though? But who
sorry,
here?
The way that, yes, Your Honor, the way that the petitioners determined the decision at the Montana Supreme Court level.
Are you saying the justices were bigoted? I'm not sure who you're charging with bigotry.
We're in the decision, yes, because in essence, it said that by they'd rather shut down education.
That's a pretty big. So you're saying the justices of the Montana Supreme Court were being anti-Christian bigots?
No, we're not saying that. We're saying that the decision was discriminatory towards religion and specifically.
I get that, but what evidence do you have that was motivated by an anti-religious bias rather than motivated by Montana's law?
Well, Your Honor, they're sacrificing the education for everyone who uses those scholarships.
I get, but you said.
I understand what you're saying, Your Honor. I think that it was more motivated. If we were able to just take a second, I feel that it is more motivated by the Montana Blaine Amendment. If they were to follow Montana State Constitution, then yes, this program.
But are you saying that the Blaine Amendment was motivated by anti-Christian bias? Is that the point?
Blaine Amendments in history have been motivated by anti-Christian bias.
But what about the one in 72, that Montana?
The one in 72 was following a pattern of creating Blaine Amendments. Supported by a group of ministers. However, this could have been a response to fear over anti-Christian riots, as my partner brought up.
Right, but I think the record shows that there were ministers in the 70s who actually said things like, if a church can't support their own school, the church shouldn't exist. We don't want the state to get entangled, and that's the lemon the lemon concern that your friends on their side mentioned. I'm not seeing.
The states are getting entangled. The importance of the Establishment Clause is to be religiously neutral, and as my opponents stated earlier, they say that the Blaine Amendment is constitutional because it does follow the United States Constitution and the United States federal law. However, it does not follow free exercise. It does not follow the second prong of the Lemon Test because it's inhibiting religion inherently.
And Mr. Maloney, I think you raised your hand.
Yes, Your Honor, you brought up the Lemon Test, and I'd like to point out that this is not the intention of how we should be determining the Lemon Test. We need to, yes, you could argue that there's entanglement, but it's for a good cause, and at that, it's excessively inhibiting religion. We need to be focused on the purpose of the statute in question, and in doing so, we can determine that this, as the respondents said in their argument, that the program is for religious and non-religious schools, and that they're treated equally, but that's just not true at all. It's completely banning religious schools from being included. So being a church and receiving a public benefit of a church affiliated school and being a regular school, it should be all the same. It's just a small bit of education that's related to religion. Yes, each religion.
And you have about 30 seconds left. Like Miss Minnie has her hand up.
Also, you brought up earlier, the important thing to note is that my opponent said that this program was shut down and that affects religious and non-religious students. But had this program been a military program, it would not have gotten shut down. The reason it was shut down was because of its religious affiliation. It was inhibited by the Montana Supreme Court using the Blaine Amendment, and it took away the students' equality of opportunity to education. It took away their free exercise.
About 10 seconds left.
The final thing I'd like to say is compare this to Supreme Court case Palmer v. Thompson, which took away the entirety of swimming pool and YMCA facilities based on race. And this program is similar because it's discriminating and taking the whole thing away based on religion.
Okay, that's time. All right, thank you very much. Another 5-minute round goes real quick. All right, Mr. Rose, Ms. Sanchez, you got 5 minutes. You can start whenever you're ready. Oh, you're still on mute, sir. I feel like my entire life now is on Zoom saying you're still on mute to all my students every day. You're still on mute. Okay, go ahead.
All right, to begin our rebuttal, I'd like to address the fact that we keep referencing this as a Blaine amendment. Well, Blaine and the Blaine argument goes back nearly 100 years. It goes back nearly 100 years from when this amendment was created. And it goes, as they mentioned, to Catholic and anti-Christian sentiment. Well, 100 years later, this was not the same case, Your Honor. The Article 10, Section 6 was created not to discriminate against Christians or Catholics. It was created to protect public school, to protect public funds from going to private religious entities. In addition to that, towards the end of at the very end of their argument, they mentioned the swimming pool exam within that case. And in this case, what they're forgetting is that the Equal Protection Clause that applies to race is very different than what we are dealing with in terms of this case.
Right, but I mean, let's talk about counsel. Let's talk about Palmer v. Thompson for a minute. That's a swimming pool case. Wouldn't the better approach, instead of having no one have access to the benefit, everyone has access to the benefit? Wouldn't that be a better approach?
No, Your Honor. And that's because we're simply not trying to entangle religion with the state, as would be the third prong of the Lemon Test.
Okay. So, Counselor, I'm sorry, Ms. Sanchez, go ahead.
And, Your Honor, I would also like to further address the Lemon Test, which petitioners have tried to use in their argument. And to start, the Lemon Test is an establishment clause. This case is a free exercise clause case. But if the Lemon Test were to be admissible in today's free exercise clause case, Montana Supreme Court would fail the third prong of entanglement. Getting involved and giving money to these religious schools would involve the state to be more entangled in religion, and that is simply not what Montana is trying to do.
I get that. I get that Montana is trying to avoid entanglement, right? I understand that element of your argument. But I think their position is different. They're saying you could give money to schools without running afoul of the Establishment Clause, right? You could have a voucher program like in Zellman versus Simmons-Harris and be fine. So if we kill your Blaine Amendment, or we kill your no aid provision, I'll call it, right, we can still comply with the Establishment Clause. I think that's how they raise it.
Well, also adding, Your Honor, that the petitioners, this far into the case, they have no standing. That the program is already abolished. Asking Montana to bring back and reinstate the Big Sky program would force it to aid religion.
Well, Ms. Sanchez, let me just interrupt you briefly. If we rule for Ms. Espinoza, your no aid provision is gone, right? I think the only way we can rule for them is to kill the Montana Constitution, Article 10, Section 6. So that would be there. But let's talk about standing for a minute. I think it's important. I'm a little uncomfortable with this argument, right? You say, well, maybe their rights were violated in the past, but we just killed the program. Can't they come to court because of how their rights were violated in the past? Isn't that enough? Mr. Rose, you can go for it.
May you repeat the last part of your question? I'm sorry.
Sure. Let's assume their rights were violated in the past. Isn't that enough to have standing in the present? Isn't that enough to have an injury in the present?
No, Your Honor. The fact that this Big Sky program was created in the first place is what is truly the issue. Under Montana 10, as we have said time and time again, creating this program was already an issue. So it shouldn't have been created in the first place. Thus, meaning that this entire incident shouldn't have been created in the first place. And the Montana Supreme Court, who is the highest authority on their law, has already decided handily that the entire program should be abolished because it violates Montana 10.
And you have about, Counselor, about 25 seconds left, so you can move towards conclusion.
Thomas Jefferson has mentioned in a letter to the Danbury Baptists that a wall of separation is between the church and the state. Now, this wall can be raised, but this wall cannot be lowered. It has pores to allow certain aid to go through, but it cannot be abolished and destroyed. What this case...
Okay, Counselor, that's time.
Destroyed the wall.
Thank you so much. You guys love my ringtone by now, I'm sure. Thank you all so much. That was fantastic. I asked you really hard questions. You can tell that was harder than the last round, right? Yeah. I brought in the standing argument, which I didn't bring up last night. That was a little bit harder. I tried to go a little bit more into Trinity Lutheran with Justice Gorsuch's concurrence and the footnote 3. If you haven't had a chance, go read the Gorsuch concurrence after this. I think maybe you had a general gist, but just read it carefully. I think it's a very hard aspect of the case. I'm glad you brought up the Palmer v. Thompson swimming pool case. I think it's a very good thing. And I think the petitioners brought it up. I think Avery had a good response with the protections a little bit different. I gave you some really hard questions. I think you did very well. I am so proud of you. I don't know which teams are going to advance. We need to go all 4 rounds to see this, but you guys did fantastic. It was excellent. Sebastian, is there anything you'd like to add?
Yeah, those were some very difficult questions. They made my head spin at certain points. But yeah, you all did a great job. You were here for a reason, and it definitely showed. So well done.
Very good. Are there any questions from the students? I'll get to the teachers in a minute. Well, teachers come second. Any questions from Avery, Brooke, Dylan, or Dylan? No?
I just want to say thank you for your time.
Oh, thank you. And I think your sister was in this a couple years ago, right?
Yeah, she did.
Oh, well, I'm glad to have her. Well, thank you. Avery, was that... I'm sorry, you say something also?
Nice to meet y'all.
If you're ever in Houston, at least the Dallas people, assuming you're allowed to leave your houses, if you ever come to Houston, you're welcome to visit my common law class anytime. Open invitation. I mean that sincerely. If you ever want to come to Houston, you can come by. Actually, I'm probably going to be teaching on Zoom next semester, so you can just watch my class probably just as well. But if you ever drive to Houston, you guys, are you juniors, seniors? What year are all of you?
Juniors.
Junior.
Freshman.
Junior.
Okay, freshman, junior. So we got more time. But if you're ever in Houston, driving through, you're welcome to come by my class. Open invitation. Questions from the teachers. I know teachers always have questions. From Greg or Aaron?
Mr. Seal, no question.
Greg, you're on mute.
He's muted.
There you go.
Yeah, this is my life. Tell my students, you're on mute. I tell this 100 times a day.
After Brooke mentioned Lukumi, you challenged her with another case, and I think you said Maze?
Masterpiece Cake Shop.
Okay, Masterpiece.
Masterpiece Cake Shop was decided about...
Okay.
Yeah, I'll give the background. That was a case for about 2 years ago. It involved a baker in Colorado who didn't want to make cakes for same-sex weddings. And there was evidence in the record that the government official who punished him had made statements about Catholicism and Christianity, saying how this is just bigotry and it's like they're Nazis and stuff. And the court found a violation of free exercise based on Lukumi. So this was a recent precedent that didn't involve criminal. I think Brooke had said something about criminal law, and the Masterpiece Cake was about civil. So that's why I asked that question, which it was in your materials. Don't feel bad if you didn't know it, but I'm trying.
I know the case very well, Josh, and you and I might have an interesting discussion over what it means. I found it to be more of a due process case than an equal protection case.
I actually visited the Masterpiece Cake Shop as well. I was in Denver, and I stopped by.
Cool. We could have done that. We were in Denver last summer or last spring on a moot court competition. We didn't think to do that.
All right, Aaron, I think you have I'm sorry, Mr. Seal, you have another question?
No, I wanted to know that. I did want to tell you, Josh, and I want to clarify this, all right? I have always looked at virtual as being a closed world. Yesterday, I was talking with Jonathan Ray, and he said, no, this is an open world. You're expected to do all the outside research and find everything you can, including Masterpiece and all the other cases. Help me understand. Are we closed world in this competition, or are we open?
We're open. I've never said you're restricted. The sky is the limit.
I misread the rules. When the rules said that you have to include these things in your brief, I took that as being a restriction, and I was wrong.
Oh,
so
well, your team did well in spite of it, so don't worry about it. Aaron, I think
I didn't handicap them too much.
No, they did well. Aaron, I think your hand was up also.
Well, first to my colleague, we're always our own worst critics. So no matter, we'll watch an hour worth of rounds and pick out things that we feel like we left our kids hanging on. I was apologizing for remonstrance last round, so I feel you, sir, even though I haven't met you. The question I had for you, Josh, is there an argument to be made to thread the needle here for judicial minimalism in terms of your question about striking down Section 10 or Article 10, Section 6 and restricting it a la what was done in Planned Parenthood versus Casey and Masterpiece Cake Shop, that the more restricted argument, finding that just in this case there's no harm done, or that the program could continue, or that we're going to outlaw this but it doesn't have further impact. Is that one argument to take to the next level?
I'm not a fan of phrases like judicial activism and judicial restraint and minimalism. I don't really know what those phrases mean, so I try not to use them. But I would say that you could argue the Supreme Court has a role here of not challenging state law when they don't have to. And the Montana Supreme Court has done a good job of interpreting their own constitution, and the Supreme Court should intervene. So if you want to call that minimalism, you can. I would call it maybe federalism, I think, which maybe one of you mentioned, where you're letting the states run their own. No, I think that was actually, Aaron, your previous class, one that mentioned federalism. You're deferring to the states, so I think that's a credible argument.
I appreciate that. I really do. Thank you for asking that, because I've been trying to get at that point with the kids a little bit, that the Supreme Court should, whatever it does, should interpret everybody's laws to stand if they can, if there is a reasonable way of preserving Montana law, then that's what the Supreme Court should do. And I think, Aaron, that's the point you're making, right?
Yeah, to some extent, or even say that while this program and this aspect of the interpretation of the Blaine Amendment was too great of a reach, that doesn't subsequently overwhelm Comey or any. It doesn't have further impact for other uses or other interpretations of the Blaine Amendment. I think you said in the other 36 of 37 states, or trying to keep my facts straight here, but saying this one is wrong, in one way or another, regardless of what SCOTUS ultimately does, it may not have a precedential impact or a sweeping judgment. And the court seems to be doing a lot of that lately, a lot more so than what it used to do, rather than creating, selective incorporative arguments. They're saying, okay, fine for Masterpiece case, we're going to pull back on the Civil Rights Commission, but that doesn't mean you can't make other restrictions in the future. It's just that in this case, it's not right.
All right, I have another round in about 2 minutes. We have to call this one to a close. But I thank you all. I am truly grateful. We'll be putting these videos online on YouTube later tonight, so you can go and pore over them. But thank you again. And if you have any questions to the students, you can email me directly. Happy to help any way I can.
One last question. Have you given any grades, anything from the first round?
I can send you an email later.
Okay.
Thank you so much. I'll talk to you all soon, and best wishes.